Everybody ready? Okay. Good evening and welcome to the Kent County Board of Adjustment meeting for February 16th, 2023. We're going to call the meeting to order or the public hearing to order. And at this point, will you call the roll, please?
Absolutely, thank you. Mr. Jenkins.
Here.
Ms. Hudson.
Here.
Mr. Jones.
Here.
Mrs. Denny.
Here.
Thank you. We do have two members who will be recusing themselves this evening. That's Mr. Nichols and Mr. Cusick. And we do have one vacant seat on the board right now. So we do have a quorum with the 4 members present.
Thank you. This time I'm going to ask everyone to rise and pledge allegiance to our flag. Any additions or alterations to the agenda?
We had just posted the amended agenda last week after the original was posted, but that amendment, there's been no further amendments.
Thank you. Okay, so when you're ready, introduce the public hearing.
Thank you. Hi, good evening, ladies and gentlemen. My name is Jason Berry, and I'll preside as hearing officer this evening for tonight's public hearing. This hearing is being conducted for the purpose of providing testimony on the appeal before the Kent County Board of Adjustment tonight. The procedure on this appeal will be as follows. The staff will read the legal notice into the record. There will then be opening statements by both the appellant and then by the department. Next, then, will be presentation of evidence by the applicant regarding its appeal, followed by presentation of evidence by the department in support of its position on that appeal. After that, there will be a chance for rebuttals if needed. Finally, then there will be closing statements given by both the appellant and the department. And then finally, public comments, if permitted by the board, and if permitted, they would be limited to 3 minutes per person. Thank you. If there is a group of interested citizens in favor or opposed at that point who want to speak about the application or the appeal, they may wish to elect one spokesperson among them to make their comments to the board. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. To make statements, please come to one of the podiums in the front of the room here. And for the record, then please give your name, address, and allow our attorney to swear you in prior to providing any testimony. Copies of any written statements or exhibits used and presented during the hearing should be given to the staff for identification so that they may be included in the permanent record for this appeal. A decision on the appeal will be made during the business meeting following the public hearing this evening. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on this appeal. If you do not wish to wait for the business meeting later this evening, you may call the Kent County Planning Department tomorrow between 8 o'clock and 5 o'clock at 302-744-2471, or you can check the Kent County Planning Department website or the Kent County Public Notice page to learn of the board's ruling. The applicant will receive written notification of the board's decision. This notice will not be mailed until after the next scheduled hearing. The public notice of this evening's hearing was published on January 29th, 2023 in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of this application. Thank you.
Thank you, Mr. Berry. At this time, we're going to have a statement by counsel, the intention of which is to let those who are going to give testimony this evening understand what is and it would not be acceptable as testimony before this particular body. You were surprised?
I'm not sure what statement I'm supposed to be giving at the moment, so I apologize, everyone.
It's quick check pro.
Yeah, so that's pertaining.
It really doesn't apply to what we're doing.
Correct,
Okay.
correct.
So we're just going to
We're good.
skip that. Do we need a motion to do so?
I don't think
okay,
so.
We're going to skip that. Okay, so public hearing.
Well, great. So as I mentioned, we're on to our application for this evening. I'll read through the legal notice and then go through just some pictures of the property there before the attorneys start their section. So this is application A2228, Morgan Branch Solar LLC. Owner of the property is Christopher Cartanza, trustee. They seek an appeal of an administrative decision to refuse a conditional use application determined to be incomplete by the Planning Department in accordance with Kent County Code Chapter 187. There are 3 properties involved in this request. One is located on the south side of North Little Creek Road, 877 feet east of US Route 1, south of Dover, in the 3rd Levy Court District and zoned AC. The second property is on the south side of the intersection of North Little Creek Road and Long Point Road, southeast of Dover. That zoning is AC. And finally, the final property located on the northeast side of the intersection of Quaker Lane and North Little Creek Road, east of Dover. That zoning is also AC. And I'll just quickly go through our exhibits and the property. These are the properties in question for the appeal. Again, those properties outlined. These are the photos of the parcel here. And that's all for our presentation. We wanted to make sure to leave plenty of time for everyone else this evening. So I think we're on to the item 2 here in the public hearing, opening statement by the appellant.
Thank you, Madam Chair, members of the board, and staff. For the record, my name is John Pardee. I'm an attorney with the law firm Baird, Dallas, Brockstedt, Federico, and Cardia here in Dover, Delaware. With me tonight are Sam Judd and Ashley Smith. They are senior development managers for Morgan Branch Solar and will be providing testimony tonight. And we have a number of submissions that we've put into the record already. They were delivered to the county last week, but I do want to, for the record, indicate and identify what those submissions are. First is a factual chronology. It's a rather large notebook with a number of exhibits in it, so you should have a copy of that in the record. There is a legal memorandum with exhibits. It's another relatively thick notebook that you should have. We have a PowerPoint presentation, which I will be asking Mr. Berry to put up on the overheads very shortly. We have a review of the staff's March 4, 2022 sketch plan submission, and also a document that is entitled a review of the Planning Department comments in a rejection letter dated March 22nd, 2022. We have a lot of material to cover tonight, so in the interest of time, I'm going to keep my opening comments very brief. If I could ask Mr. Berry to show our PowerPoint, we'll start there. So the name of the project is Morgan Branch Solar. The entity that is the applicant is Morgan Branch Solar 1 LLC. And as you've seen, this is the location of the 3 properties involved in the application. I want to explain kind of how we got to where we are tonight. So the public record will substantiate that we filed suit in the Court of Chancery in May of 2022 after our application was not permitted to proceed forward. And so we're here tonight in an effort to exhaust our administrative remedies via appeal to the Board of Adjustment. We are not going to ask you to adjudicate all of the remedies or claims that are alleged in our Chancery Court pleadings. For example, we're not going to ask you to adjudicate claims of vested rights or equitable estoppel or constitutional claims, but we are going to ask you to adjudicate the claims that you see on the screen here. So the first claim is that the Planning Department erred by delaying acceptance of our sketch plan submission when it met all code requirements as early as March 4 of 2022. We also allege that the Planning Department erred by refusing to accept our preliminary site plan application when it met all code requirements as of March 22nd, 2022. Error by treating our sketch plan submission and our preliminary site plan application differently than those of other similarly situated applicants, and in particular, you'll hear about Cedar Creek and Calpine. The fourth alleged error is that the department ceased further processing of our preliminary site plan application on the basis of Ordinance LC 2205, which was adopted on the evening of March 22nd, 2022. And we allege that that ordinance cannot be applied to our application because it violates the uniformity requirement in Title IX, Section 4902B of the Delaware Code, and that it was enacted without proper notice as required by Title IX, Section 4926 of the Delaware Code. And then the last contention that we have is that the Planning Department erred by ceasing further processing of our preliminary site plan application on the basis of a moratorium ordinance that was designated as LC 2209, adopted on April 26th of 2022. And we allege that that ordinance cannot be applied to bar our application because it was introduced in violation of the Freedom of Information Act, particularly Title 29, Section 10004. It also violates the requirements of Title IX, Section 4110J regarding emergency ordinances. And lastly, it violates the uniformity requirement of Title IX, Section 4902B. Contrary to what you'll hear from my good friend, Mr. Walton, you do have jurisdiction to adjudicate each and every one of these claims for the reasons that are set forth at pages 25 through 31 of our legal memorandum. I'm not going to bother going through that. In the interest of time, you have that in the record, and it's our contention that you have jurisdiction to adjudicate every single one of these contentions. We are not going to ask you to invalidate any levy court ordinances. We're not here to ask you to strike down an ordinance. We're just here to argue that those ordinances cannot be applied to this application. And we believe that we will be able to demonstrate that Ordinance LC 2205, which was adopted on March 22nd, banning solar projects in the AC zone district outside the growth zone, and Ordinance LC 2209, the moratorium ordinance that was adopted on April 26, cannot be applied to the Morgan Branch solar project. And finally, I would note that the agenda for tonight's hearing, as Mr. Berry indicated, affords an opportunity for the public to comment. We would respectfully object to the board accepting any public comment on this matter for the reason that this is a quasi-judicial appellate proceeding between two adversarial parties, very much like a trial in a court of law, where you serve as the judge and jury. It is not a matter of public business, like an application for a land use application, and therefore it's our view that public comment is irrelevant and inappropriate. So I just make that objection for the record. I expect that you will in fact receive the public comments, and we reserve the right to respond to those as well. So that is my opening statement, and I believe that my colleague, Mr. Walton, would like to use the technology.
Excuse me. Thank you, members of the board. My name is Max Walton. I haven't been here in a long time. I'm with the firm of Conley Gallagher in Newark, Delaware, and at council table with me is my colleague and friend Erica Sefton, and she's going to help me with the witnesses this evening. So I thank you all for your dedication to this matter. I saw you carrying in the boxes, and wow, there's a lot of paper that got tossed in front of the board. I'm hopeful that my brief opening statement can try to wade through and simplify some of the issues before the board, because there are just a few straightforward questions that I believe the board needs to decide. So I believe Mr. Edwards placed in front of you a spiral-bound packet, which I'm going to use as I go through my opening statement. I'm going low-tech this evening because I just thought it'd be easier. So if we take a look at the statutes that create the Board of Adjustment, they are in Title 22, Chapter 3, Subchapter 2 of the Delaware Code, and I provided those for you. And then that's Section 205-399 and 205-400 of the Kent County Code. And I am sure that, like most boards of adjustments, you usually hear and decide variances. There was a reference earlier to Quick Check. That's governed by 327, Section A3, which establishes the board's authority to grant variances. But in this case, we're not proceeding under the variance. We're proceeding under the board's appellate authority, and that's under 327A1. And what does that authorize you to do? To hear and decide appeals where it is alleged that there is an error in an ordered requirement, decision, or determination made by an administrative official in the enforcement of this chapter or of any ordinance adopted pursuant thereto. So if you go down, it also says, in subsection B, it says, in exercising powers provided in subsection A, the board may, in conformity with this chapter, reverse, affirm, wholly or partly, or may modify the order, requirement, decision, or determination appealed from. And then it goes on, and to that end shall have the powers of the officer from whom the appeal is taken. That's what it says. So the board has the same powers as the official from whom the decision was made. And if there's any questions, section 324, if you follow that along, the appeal may only be taken from the administrative officer. So I emphasize, the board can only take such action as the administrative official can take, and that's 399 and 400 of the Kent County Code. Basically says the same thing, but they wrote it a little better in the Kent County Code. So there is not jurisdiction for this board to declare the ordinances invalid, or as my friend spoke about, say the ordinances don't apply to their application. There's no jurisdiction to override any decision of the levy court, nor is there jurisdiction to hear any equitable claims or disparate treatment claims and the like. There's no jurisdiction for the board to hear and rule that the actions of the levy court violate state law in some way. There is no court in the country that has held that a board of adjustment can invalidate an action or ordinance of the levy court. So the board's jurisdiction relates to taking an appeal from an administrative officer. We just heard there was a list of all of these claims that they want to bring and ask this board to decide. I submit to you that that's white noise. So let's talk about what's really at stake. What's at stake is whether ordinance 22-7, so we have our terminology straight. I'm going to call that the moratorium ordinance, so I don't have to keep saying 22-7. So what's at stake is whether the moratorium ordinance bars the claims brought by Morgan Solar. There's no dispute that that was introduced on March the 8th, and it has an effective date retroactive to introduction, which was which was adopted on April 26th, but retroactive to March 8th. And Section C of the moratorium ordinance states, applications for which a pre-application meeting has been conducted prior to the effective date shall be exempt from this ordinance. So if you had a pre-application meeting before March 8th, you're exempt. And if you didn't, you were subject to the ordinance. Where does that pre-application meeting requirement come from? And that's in 18736. And if you follow along in my statutes, I tried to provide you all these statutes, and they say that the sketch plan must be submitted to the commission staff at least 5 days prior to the preliminary conference. So what we're going to argue about here is they were submitted on March 4th, and there wasn't 5 days before March 8th that they could have met the deadline. So you can rule on that basis alone. The evidence will show that they didn't submit a viable sketch plan by March the 8th, which is the effective date of the moratorium ordinance, so they can't meet that deadline. And again, that should be the end of the road. If you make that decision, the pending ordinance doctrine, which was referred to in our papers, and I've given you the case of Covington versus City of Rehoboth Beach, which is in your packet, is the pending ordinance doctrine, but that forecloses any further consideration. In this case, though, there's a little bit of an overlay. And what that talks about is the ordinance 22-5 entitled Solar Facilities. So just for ease of reference, I have the moratorium ordinance, and I'm going to call this one the solar ban ordinance. We got them all straight. That ordinance was introduced the solar ban ordinance was introduced on February 8th, and it was adopted on March the 22nd. And that ordinance provides that valid applications which a pre-application meeting and a formal preliminary plan submission has been paid for, and I emphasize, and accepted by the Department of Planning Service prior to the effective date shall be exempt from the ordinance. That's Section 8 of the solar ban ordinance. So what does it mean to be accepted? We go to the code. And that's section 18738D and E. And the code makes clear that there are two general requirements for site plan submission. It has to be prepared by a Delaware professional engineer, and it can be an architect and other things. And it must be prepared in accordance with the appropriate checklists. And then you go down to subsection E. And then the commission staff, which is my client, reviews that to determine compliance with the pertinent features of the chapter and the comprehensive plan. And it says, applications determined to be incomplete by the director or the designee shall be returned to the applicant. And that's exactly what happened here. It was deemed to be incomplete. And the plan is not complete unless it complies with the pertinent features of the zoning and the subdivision code. And the evidence is going to show that the preliminary plan submission was not in compliance with the code, and we do not believe it was prepared by a Delaware professional engineer. We'll find that out today. I don't think you're going to hear from any Delaware land surveyor indicating they prepared the plan. It didn't have the pertinent features, and I think that you're going to see by the testimony that the preliminary plan submitted on or about March 22nd was incomplete and not acceptable. And because the requirements of the solar ban ordinance were not met, because a formal preliminary plan submission was not paid for and accepted by the Department of Planning Services prior to the effective date, you must reject their appeal. I think you're going to hear tonight a lot of what we did was good enough, but that's not good enough. The plan needs to be complete and accepted and in compliance with the code. So I'll turn it back over to my friend John and let him present the evidence.
Madam Chair, would it be acceptable to ask the witness questions from the table?
Certainly.
Thank you very much.
As long as we're hearing it on the record, I think it's appropriate.
Thank you. I appreciate that. We have a lot of exhibits to walk through, and I think it would just be a lot easier. So we'll call as our first witness Ashley Smith, and I believe you would like to have her sworn. Is that right?
Absolutely. Can you state your name for the record?
Ashley Smith.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Berry, could we have the third slide of our PowerPoint placed up on the screen? That's it. Thank you very much. Ms. Smith, may I call you Ashley?
Yes.
Okay. Ashley, you've already stated your name for the record. In the spring of 2022, by whom were you employed?
Dakota Power Partners,
And what was your position or job title with Dakota?
Director of Development.
And what were your job responsibilities or duties with Dakota?
So I led the project development of multiple early and mid-stage utility scale solar projects. My main focus was on land acquisition, engineering, and permitting.
And when did you start your employment with Dakota in that position?
November 16th, 2020.
And am I correct that you are now employed by a different company?
Yes, I'm employed by Enel,
And what is your position or job title with Enel?
Senior Development Manager.
And just for the record, Enel is spelled E-N-E-L. And what do you do for Enel? What are your job responsibilities?
So similar task to what I did at Dakota, but now I'm working on moving some of the mid-stage projects to a later stage, still focused again on land acquisition and permitting, and then focusing on engineering construction now.
And when did you start with Enel?
This past Monday, the 13th.
Okay. What is your educational background?
So I have a bachelor's degree in civil engineering from the University of South Carolina, and I have a master's degree in construction engineering and management from the University of Michigan.
And do you hold any professional designations or certifications?
I do. I'm a licensed professional engineer in the state of Colorado, and I also have my LEED AP, which is an accredited professional for the leadership in energy and environmental design.
Are you familiar with a project called the Morgan Branch Solar Project in Kent County, Delaware?
Yes, I am.
And if you don't mind, for the ease of our audience, I will just refer to that as the MBS project or the project. Could you tell us a little bit about the MBS project generally?
Sure. So it's a utility scale solar project, including some ground mounted solar panels, inverters, batteries, and other associated electrical equipment. Essentially, the panels absorb the sunlight to convert it into electricity, and that electricity is sent to the power grid for distribution and consumption by customers. Also, just to elaborate a little bit more, although Mr. Berry and the slide did a great job, the MBS project does consist of 4 parcels, all owned by Christopher Cartanza. They're under a purchase option agreement by MBS that was executed on September 30th of 2020. There's 1 parcel located in the city of Dover. The other 3 are in the jurisdiction of Kent County that were up on the map. The Kent County parcels are in the AC district outside the growth zone, and they're currently being farmed.
And what was your involvement in the MBS project?
So I have been involved in the project since November 2020 when I started with Dakota. So prior to the project being acquired by Enel, I was on the early stage activities again, so acquisition and engineering and design. In May 2021, Enel acquired the MBS project from Dakota Power Partners. I became a consultant after the acquisition. So after the acquisition, Sam Judd was assigned as the lead developer for MBS, and I became a consultant to help continue the development for the project. I also assisted MBS in preparing and submitting the sketch plan, the PLUS application, and the preliminary site plan.
Have you seen the factual chronology that we have submitted into the record for this hearing?
Yes.
Is it this large notebook in front of you?
Yes.
Okay. And did you help me prepare this document in anticipation of this proceeding?
Yes.
Do you have firsthand knowledge of all of the facts in this chronology relative to the preparation and submission of the sketch plan, the PLUS application, and the preliminary site plan application for the project?
Yes.
And do you attest that all of the facts in this factual chronology relative to the preparation and submission of the sketch plan, the PLUS application, and the preliminary site plan application for the project are true and correct to the best of your knowledge and belief?
Yes.
Do you recall how and when the MBS project team first began to interact with Kent County relative to the project?
I do. I first want to provide a little background information for the board. So when Dakota Power Partners first started developing the MBS project back in 2019, which was several years in advance of LC 2205 and 2209, which is the moratorium and the Cedar Creek project, the county interpreted solar projects as public utility and public utility uses, which were permitted as a conditional use in the AC district. That's the same district that the MBS project is located. There were multiple solar projects approved per this provision in the past with little opposition. As a developer, we don't try to pick locations where we anticipate permitting issues or major opposition. Rather, we saw this project as an opportunity to achieve some state renewable energy goals while giving landowners in the farming community a steady and predictable income. We were under land contract far before the Cedar Creek Solar Project submitted their CUP application, which, as we all know, forever changed the landscape of solar projects in the county. In September of 2021, we started hearing about some opposition to the Cedar Creek Solar Project, a project larger than the MBS project, but located in the AC district outside the growth zone, just like the MBS project. MBS had already submitted deposits to PJM of $214,000, and we had spent funds in excess of $300,000 on development of the project. NBS had invested substantial money and time into the project, so when we heard that there was the possibility of a solar ordinance being drafted, my colleague at Dakota Power Partners, Tim Daniels, and our consultant, Laird Stabler, reached out to Commissioner Eric Buxton to discuss...
Excuse me, Excuse me, I'm going to have to lodge an objection. We're reading from a prepared script. We're not giving testimony, number one. And number two, the testimony about the amounts of money that they have spent are relevant to the issues before the board today. We have already stipulated that there isn't a vested rights claim.
This is just background information. I've already said we're not planning to ask the board to rule on vested rights. And with regard to the notes that are being testified to from by the witness, we can certainly make those a part of the record. There's nothing in the board's rules that preclude that. We have a lot of material here, and the witness needs to be able to reference her notes in order to testify. So I hope that my colleague doesn't intend to continue making objections along these lines. This is a pretty basic procedure here, and the witness should be allowed to testify.
As far as I'm concerned, I want to hear the testimony. I think it's important that the board generally hears the testimony. It does, reading it is different than giving testimony. But in this particular instance, at this point, we're not asking questions. And so we can't ask questions for you to feed us. So I think I'm going to allow you to go on. But it would be nice if it didn't sound just so scripted. I'm sitting here thinking that myself as this is going on.
Madam Chair, if it would help, I'll ask the witness to try to testify without the use of her notes as much as possible, if that would help. I can appreciate that you'd like it to be a little more lively than just being read to.
It would be helpful, Mr. Pardee, if she could if you could ask questions and she could give testimony. I think that feels more the way we normally do things here.
Sure, I'll be happy to do that. I'm sorry, I believe that the last testimony you gave was that your colleague, Mr. Daniels, and consultant, Mr. Stabler, had reached out to Levy Court Commissioner Eric Buxton to discuss the project and the ordinance that you'd heard about. Is that right?
Yes.
And was that your first interaction directly with the county?
Yes.
Okay. And are you aware that on September 1st, 2021, the Regional Planning Commission recommended approval of the Cedar Creek project?
Yes.
And are you aware that on September 28th, 2021, the Levy Court voted 4-3 to deny the Cedar Creek project?
Yes.
And are you aware that Cedar Creek subsequently filed an appeal in the Court of Chancery?
Yes.
I'll ask you to take a look at Exhibit A in the factual chronology. Is it your understanding that on October 12, 2021, the Levy Court introduced Ordinance LC 2121?
Yes.
And was that a moratorium ordinance that proposed a 3-month moratorium on utility-scale solar facilities?
That's correct, but it was subsequently not adopted.
And that draft ordinance would have been effective upon adoption, is that right?
That one was effective upon adoption, yes.
It would not have been retroactive had it been adopted.
Correct.
But you indicated that ordinance actually never got adopted, is
Never
that right?
did, no.
Okay. I think you mentioned that there was some conversation between your colleague, Mr. Daniels, and your lobbyist or consultant, Laird Stabler, and Commissioner Buxton in early November. Was that your testimony?
Yeah, so on November 9th, 2021, my colleague Tim Daniels and our consultant Laird Stabler had a discussion with Commissioner Buxton. And Tim actually shared the substance of the conversation with me, which I will in turn share with you. So Commissioner Buxton did inform the representatives of our group that there were a lot of irrational voices of concern, and he wasn't looking to ban solar. He understood it was good for the economy. He was hoping to strike a balance between the agricultural community and the solar community. He had no intentions of taking away landowner rights. He told Tim that if there were projects that were already under development, he was not looking to stop those. He wanted to find a potential middle ground to let the existing projects move forward. He said to talk to Sarah Kiefer, who was responsible for drafting a solar ordinance.
And before the next question, I'm just going to make a blanket, so I don't have to interrupt you again. This is all hearsay upon hearsay, so I'm going to make a blanket. You can give your testimony. I just want to make sure that I have an objection in the record that It's hearsay upon hearsay.
Understood. I'll just indicate for the record that hearsay testimony is acceptable in administrative proceedings, provided that you can't make a material finding of fact based solely on that evidence, but it is admissible in an administrative proceeding, standard Delaware law. What happened next? Did you have a follow-up conversation with Sarah Kiefer?
Yes. So just as Commissioner Buxton had requested, we reached out to Sarah Kiefer. Just as a developer in solar, it's very common that we work with municipalities on their ordinances, since we have a lot of experience in other municipalities in finding out what best practices are. So that was our goal of the discussion. So the attendees of that meeting were myself, Sam Judd, Tim Daniels, who I'd already talked about, and Laird Stabler.
If I can interrupt, do you recall specifically what was talked about during that call?
Yes, I know specifically what was talked about. I was in that call. It was actually a very positive call. So Sarah Kiefer reiterated that the commissioners' plans were not to ban solar, but rather to give the angry mob something to quiet them down. She mentioned that Commissioner Buxton was considering an aggregate cap on solar in acreage and asked for us to look at the Newcastle ordinance, which we were familiar with, the Newcastle solar ordinance. We know that the Newcastle ordinance has a 1,000 acre cap. We did inform Sarah that Kent County has 3 times the agricultural land of Newcastle County. So, if a comparable aggregate cap would be 3,000 acres, if we were looking at Newcastle's ordinance, it would be 3,000 acres for Kent County.
And did you talk to Sarah about something called the PJMQ?
Yes, so the PJMQ is basically a list of all the projects that have submitted application to get connected to the transmission lines, to the grid. And we did look at that before. It's public knowledge. You guys can go see what solar projects are planned for your area. Our project has been on that obviously since 2019. And basically, we did a calculation that to get every project in this area that's been submitted to the PJMQ, to get that through development, it would take an aggregate cap of around 2,400 acres in Kent County.
And so did Sarah, how did she react to that?
So she liked the logic behind the idea, and what she told us is that she would probably, draft the ordinance for 3,000 acres, and knowing that the levy court would probably knock it down to something closer to 2,500.
Okay. Were there other topics discussed during the meeting?
Yeah, so we talked about setbacks and decommissioning and vegetative screen and all the things that everybody definitely should and does care about with the projects. We started just to share some of our knowledge from previous discussions with other municipalities and of what they did and what might be helpful. Again, no one ever mentioned eliminating utility scale solar in the AC district, and it was a really positive meeting. Sarah was definitely trying to do her best to draft the best ordinance for this county. And we left it that she was going to send us a draft of that ordinance so we could help her and provide some comments with some of our background that we've used in the past. So.
And did you or anyone else on behalf of MBS have to follow up on the indication that Sarah would provide you with a copy of the draft ordinance?
Yes. On November 29th, 2021, Tim Daniels did reach out to request that again. And then on...
Sorry, if I can interrupt you there. Is that Exhibit B in the notebook?
Yeah, yes. Yes, Exhibit B.
Okay, so Exhibit B shows Mr. Daniels following up with Sarah to request a copy of the ordinance. Is that right?
Yes.
Okay, and so what happened next?
So on December 3rd, 2021, we did get that draft ordinance from Sarah Kiefer. We were quite surprised, though, to see an 800-acre aggregate cap put on utility scale solar, which would not allow for all of the projects currently proposed in that PJMQ to be developed. But we started reviewing the ordinance more detail and trying to get very constructive with our comments and trying to help the county. So we started drafting those red lines.
And that draft ordinance is found at tab C of our notebook, is that right?
Yes.
Okay. And am I correct that you attended a levy court meeting on December 7th?
Yes.
And you attended virtually, is that right?
Yes, that was myself, Sam, Kim Hoffman, who was our counsel, and Tim Daniels. We joined the call virtually. We actually had worked up several bullet points from our review of the ordinance that we were going to bring up in the public comment to let the levy court and everybody know our thoughts on it. But we were surprised when the levy court made an announcement during that meeting that there would be no comments permitted on solar, and they went into executive session. So we were unable to share our comments publicly at that time.
And I believe a copy of the agenda of that meeting is at Exhibit D of the notebook, is that right?
Yes.
So you weren't allowed to provide comments that night that you had prepared, is that right?
Correct.
And so you must have been frustrated. What did you do? Was there some effort to share those comments at a later date?
Yes. So December 11th, 2021, Sam Judd with Anel did send those comments on the draft ordinance to Sarah Kiefer.
And are those comments found at Exhibit E of the notebook?
Yes.
Okay. And what happened next? Did you have any conversations with anyone at the county about the comments?
We did. So on December 13th, 2021, so 2 days after we sent the comments, we did have a call with Commissioner Buxton, and that was myself, Sam, and Laird Stabler. Tim Daniels was not on that call. And
what did you discuss during that call?
so we basically went through kind of the high-level points of our red lines, which were centered around acreage caps, which we kind of already talked about, lot coverage and the calculation of lot coverage, setbacks, and also landscaping. Those were kind of our four main highlights that we wanted to discuss with him. Yeah.
I was going to say, what was Commissioner Buxton's reaction at the meeting?
He took it all in. He definitely was listening very carefully. He was in a tough spot, obviously, in that situation. And he reiterated that he really wanted to strike that balance and he didn't want to take away landowner rights. And so he just reiterated work with Sarah Kiefer. He thought all of that information was very helpful and just, encourage us to keep working with her.
So were you attempting to help the county write a better ordinance?
Absolutely. So if you look at our comments, it wasn't let's just try to have the developer run over everything. We really brought the best practices from other projects that we've done and other folks that we've worked with to help create the most complete ordinance that covered everything that really should be covered to make sure that everybody is taken care of.
And was a actual copy of your written comments ever sent to Mr. Buxton?
Yes, so right after the meeting, we sent the same copy that we had sent to Sarah to Commissioner Buxton for his reference as well.
And did he respond in some way?
He did not. Well, he responded in just saying work with Sarah, but it wasn't anything specific to the points in the red lines.
Okay. Are you aware that on December 21st, 2021, there was a public hearing on a second application for the Cedar Creek project?
Yes.
And is the record of that proceeding at Exhibit F of our chronology?
Yes.
Okay. And do you recall the vote? There was a vote to deny the application, but that vote failed. Is that your understanding?
Yeah. Yes.
And is it your understanding that the application was then tabled that night?
Yes.
And is it your understanding that subsequently in January, specifically January 25 of 2022, the second Cedar Creek project was approved by a vote of 4-3 by the levy court?
Yes.
And is that proceeding found at Exhibit G of our notebook?
Yes.
Okay.
Mr. Pardee, can I just interrupt you?
Sure.
Because as if we're going to go through this whole book and the exhibits, you're going to quickly run out of time.
Not all of it.
Oh, okay.
Not all of it. I'll try to keep moving along. So what do you know about the Calpine Solar Project? Do you know when it submitted its sketch plan, when it had its pre-application conference, and when its preliminary plan was filed and accepted?
I do. So the Calpine Solar Project, they submitted their sketch plan on February 3rd of 2022. They had their pre-app on February 8th of 2022, and their preliminary application was accepted on February 9th, just 1 day later in 2022.
Okay. And is it your understanding that on the evening of February 8, 2022, the levy court introduced ordinance number LC 2205, the solar ban ordinance?
Yes.
And is that at Exhibit H of the notebook?
Yes.
And did that ordinance propose to ban solar facilities on AC zoned properties outside the growth zone?
Yes, it did.
Did you know about that ordinance on the night of February 8th?
No.
When did you find out about the ordinance?
So I found out about the ordinance on February 28th, 20 days later.
Okay. And did anyone on behalf of Morgan Branch have any conversations with Commissioner Buxton about that time?
Yes. So we actually had our consultant Laird Stabler call Commissioner Buxton, but that was at March 2nd. So it was, proposed on February 8th. We found out about it on February 28th. And then on March 2nd, we had Laird reach out to Commissioner Buxton.
Okay. And this was...
Again, I'm going to again lodge my continuing hearsay objection to this line of questioning. You can continue.
Okay. So this was the first time that any ordinance had been proposed that would actually ban solar facilities anywhere in the county. Is that right?
Yes.
Okay. Did Commissioner Buxton communicate to Mr. Stabler what your options were at that point?
He made it very clear that we had two options. The first option would be to talk to Paul Cartanza. The second option was to get our application in before March 22nd, when LC 2205 would be adopted.
And what does Paul Cartanza have to do with any of this?
So as a little background, so back in April of 2019, Morgan Branch Solar, which was owned by Dakota Power Partners at the time, we had a letter of intent signed with all three of the Cartanza brothers. So that would be Paul, Mark, and Chris. My understanding is there was an agreement or a disagreement about developing their land as part of a solar facility after that LOI was signed. And there was unfortunately a falling out. And Mark and Paul no longer got along with Chris when he decided to sign an agreement with MBS on September 30th of 2020.
And is it your understanding that Paul Cartanza was very active in speaking out against solar projects such as the MBS project?
Yes, that's my understanding.
And was it your impression that he was concerned about the merits of utility scale solar facilities, or did he have an axe to grind with his brother, Chris?
Definitely that there was an axe to grind with his brother, Chris.
Okay, so I'm going to ask this question. Is that what you were told, or that is something you bear witness to, or no?
So I have a copy of the LOI that was signed by all three Cartanza brothers.
I'm asking
Then-
about the
Yep, so-
argument, the breaking up, the whatever. I mean,
So up until the breakup and then signing with MBS, that is from my colleagues. But then from this point forward, it was for me, which he'll be getting to.
more important that we know what you know because you're physically in the room giving
Yep.
testimony.
Agree, thank you. Yep,
So you actually had a conversation with Mark Cartanza about all this, did you not?
I did.
And what did Mark Cartanza tell you?
So from December 20th, 2020 to February of 2021, I was in discussions with Mark Cartanza about a potential easement or purchase option or lease option of his property off of Cartanza Road and Bayside Drive. And we went back and forth on some options of how he might be able to get involved in the solar project. This was after Chris had signed with us. And he went back and forth. We talked through some options, and ultimately he came back to me in February and said that he unfortunately had to turn it down because he specifically disliked his brother so much he could not do it.
Okay, let's talk about MBS's sketch plan submission. I think you indicated you were involved in the preparation and submission of a sketch plan for the MBS project. Is that right?
Yes.
Can you tell the board how and when the sketch plan for the project was prepared and submitted?
Of course. So the first sketch plan revision that we submitted was on March 3rd of 2022.
And is that found at Exhibit J in the notebook?
Yes.
Okay. And what happened next?
So at 8:20 a.m. on the day after, which would have been March 4th, the planning department did provide us with comments stating that the sketch plan does not meet requirements and refusing to schedule a pre-application meeting.
And is the record of that communication found at Exhibit K of the notebook?
Yes.
And so what happened next?
So at 1:13 p.m. that same afternoon on March 4th, we submitted a revised sketch plan that responded to all of the comments, including a list of Appendix D requirements and where they were shown on the sketch plan.
And is that communication found at Exhibit M of the notebook?
Yes.
Okay. Was there a further exchange of emails that afternoon?
Yes, there was another exchange of emails where we made some minor adjustments, and we ended up later that afternoon at 4:07 p.m., so this was still on March 4th. We did submit a revised sketch plan submission.
And is that found at Exhibit N in the notebook?
Yes.
And what revisions were made between Exhibit M and Exhibit N?
So all I did was add a table in the bottom left-hand corner that clearly called out all the requirements of Appendix D.
And so does the last sketch plan that you submitted on March 4th, Exhibit N, does that satisfy all of the requirements in Appendix D?
Yes.
Is there anything missing or deficient in any way?
No.
Okay. Let me ask you about a document that we've submitted into the record entitled Review of March 4, 2022 Sketch Plan Submission versus Appendix D Requirements. Do you have that document in front of you?
I do.
Okay. Can you, for the benefit of the board, tell us what this document?
Yep, so you guys should have this in front of you as well. It says Review of the March 4th, 2022 Sketch Plan Submission versus Appendix D Requirements. So this is where I'm going to go through and show you, and you can look at it with your own eyes to see where we meet the specific requirements. So hopefully everybody has that document. There's two of them, and this is the one that says Sketch Plan Submission on it. So how it's set up is the first 3 pages are Appendix D, which is again what we go through for the sketch plan requirements. There's a column that says sketch plan and has different X's in it of what we need to make sure is included. So after the first 3 pages is our actual sketch plan submission. You can see that behind. That goes from page 1 through 11. So I'll be kind of referencing some of those pages and we can flip back and forth together. So the first thing that's required in a sketch plan is the proposed name of the project, which as you can see on page 1 and all of the other pages, it is on there. It says Morgan Branch Solar Project. Number 2, accurate location map. A general location map is included on page 1. The title of that page is Morgan Branch Solar Project, location map. The next 2 say soils map and wetlands maps, general. So let's go for the soils map first. That is on page 3. Page 3 has a general soils map of the parcels that we are proposing development on.
Okay, so again, sorry, Mr. Pardee, but within this, excuse me, right next to in Appendix D, they're telling us what page it's on. Every member of this board has been given this document, and it certainly is part of the record. So I'm just wondering, do we need to go line item, or is there, I'm asking, of course, you're the attorney, but do we
Well,
have to go one by one?
I'm happy to shortcut the process, but this is perhaps one of the most important parts of the presentation in that the county has taken the position that our sketch plan submission did not meet the requirements of Appendix D. And this document demonstrates very clearly that it meets every single one of the requirements of Appendix D. So if
Okay, then just go forward. Just tell us what you want us to know then, please.
yeah, we'll try to make this
I
quick.
don't want to do anything to the detriment of your case or your opponent's case. So.
Well, I think it's important that we establish as a matter of record that each of these requirements was satisfied, so we'll try to go through it quickly.
Yep.
Can I ask you a quick question, Mr. Pardee? So if I understand correctly, there was a sketch plan that was submitted on March 3rd. Some comments were received, and a follow-up sketch plan was submitted like midday. Comments were received, and then a third sketch plan was submitted the end of the day on the 4th. Is that correct?
That's correct. So
Okay.
March 3rd,
Yep.
early March 4, later March 4. And this later March 4 is the one we're talking about, is Exhibit N.
So my question is, on all these references in the table, is that pertaining to the final one that was submitted at the end of the day on March 4th?
Yes.
Okay.
Thank you for the clarification. So Ashley, if you could run through these fairly quickly and just indicate where each one is shown in the plan.
Of course. So the next ones are the name and address of the owner of record, applicant, equitable owner, and surveyor or engineer. If you go to page 2 on that, those are called out in both the table and the spot on the top left of that page.
By the way, I'm sorry to interrupt you, but can I ask you, is Sam Inc. a licensed Delaware surveyor or engineer?
Yes.
Okay. And so after that, what's next?
The scale is included on pages 8 through 11 in the bottom left-hand corner. There is a scale on those pages. Date of preparation, those are also on pages 8 through 11 in the bottom left-hand corner. You can see the date was March 3rd, 2022. Accurate north arrows, those are on each of the sheets as well, on the right side. Boundaries of land to be subdivided, there are no lands being subdivided, so that is not applicable. Dimensions of the property. On every single page that is part of the site plan here, there are acreages of each of the parcels included. Any other dimensions can be determined from the scale. A data column with at least the following information: county identification number, zoning classification, total acreage within the boundaries, total acreage within stormwater management area, total acreage within other boundaries such as the wetlands, dwelling units, and average lot area. Those are all on pages 8 through 11. This was the table that I added in just to make it incredibly clear. It's the white table in the bottom right corner, so it specifically lists out each thing. And then that also in that is total acreage of woodland preservation, proposed use, and relation to the growth zone, all included in that table, so that we know that we checked every single box that was required for that sketch plan. Topography contours at 1 foot intervals, that is also on page 8. The light pink lines, those are 1 foot intervals of topography that are taken from USGS. That reference to USGS is included on page 6 at the bottom. So again, clearly identified. Location of existing property lines, streets, alleys, easements, buildings, structures, utilities, wooded areas, water courses, tax ditches, wetlands, and other significant or man-made features. As applicable, those are on pages 8 through 11. You can also see the aerial, which will help you identify the location, the use of the land, local buildings, and other parcels. Proposed use, that is utility scale solar facility, that is clearly identified on page 2, 8, and through 11. And also an overall layout. That's again included on pages 8 through 11. Shows the solar panels.
I'm sorry if I may interrupt. I think you jumped over the delineation of the 100-year floodplain.
Oh, I did.
Is that shown on page 5?
It is. Yep. The floodplain is shown in blue on page 5.
Okay, I'm sorry I interrupted you.
No, thank
you said
you.
the overall layout is on pages 8 through 11. What else?
So list of all proposed utilities, drainage facilities, parking facilities, which are not applicable in our situation, and structures. Again, all on pages 8 through 11.
What about the layout and dimensions of all streets, alleys, and entrances?
That is shown too. We have stars shown for all the entrances. We have a gray line shown for all the 16-foot wide streets within the site, the roadways within the site that go in between all the solar panels, inverters, and batteries.
And then what's on page 3?
Let me just, the last page of the Appendix D. It just says required and dimension buffers. So we show all of the setbacks in the table on pages 1 through 8. And we also show the vegetative screen that we were planning on putting in with the green line going around the boundary of the site.
So as of the afternoon of March 4th, when you had submitted Exhibit N, I understand it's your testimony that that submission satisfied all the requirements of Appendix D. Is that right?
Yes.
And so what happened next?
So at 4/24, the planning department did provide us with a copy of a sketch plan submitted for a similar utility scale solar project by Calpine that we had mentioned before. So they sent us that.
What did they tell you to do with that?
They told us, and here's the quotes, use this as a model to emulate for purposes of ensuring compliance with Appendix D requirements.
And is that document found at Exhibit O of the notebook?
Yes.
Okay. What happened next? Did Sam Judd reach out to Jamie Fenske the next day?
Oh, let me see. Well, I would like to point out first that the Calpine example that they sent us, it was actually had the exact same information presented on it that we had. However, the Calpine sketch was prepared using a computer program called AutoCAD, which is not a requirement of Appendix B of D.
Okay. Thank you for clarifying that. So what happened next? Did Sam reach out to anyone the next day?
Yes. So clearly, we were a little confused on what was missing because we had checked every box on Appendix D and had just been passed basically an example of another solar project's sketch plan and said, just do this to align with Appendix D. So at 7:46 a.m. on March 5th, Sam Judd requested of Jamie Fensky, can you please specify which applicable item is missing from the checklist in our sketch plan?
And that's found at Exhibit K, page 1 of the notebook?
Yes.
Okay. And then did Sam reach out to anyone else?
So right after that, at 7:55 a.m. on the same day?
I'm going to make an objection. Mr. Judd is here on the witness list, so maybe he should testify about what he did.
She's testifying from emails that are a matter of record. And, you know, we can stop and have Mr. Judd come up here, or she can just point to the emails. Mr. Judd's going to testify later and corroborate everything that she's saying. You know, these are the kinds of objections that are just going to drag this hearing out. We're trying to get through the story.
Well, Mr. Pardee, I'm absolutely, I kind of lost my paging here, but for a minute, but because different things are written twice, but frankly, I'm following along, and all of us have had time to read this, but I do not want, I don't want objections, and I want you to be able to present the testimony that is necessary for you to present your case. But truly, I don't think, it does feel as though you're sitting there reading this, and which is to me inappropriate. And would it be easier if, when we heard from Mr. Judd, we kind of went back to what he did and what he said and leave it at that? But we do have these emails in front of us.
Right. So I will try to avoid asking her to testify as to what somebody else said, although I will point out, Madam Chair, respectfully, that's not prohibited in administrative hearings.
I understand.
And it's also not prohibited for her to read from notes. So I will try to move along in accordance with the chair's instructions as best we can. And I thank you. Let me try to return in that spirit.
Thank you.
Did MBS ever get any comments, any specific comments back from the planning department on the submission at Exhibit N?
No.
And so did MBS then proceed to reformat its sketch plan to look more like the Calpine example?
Yes, we were confused because we had submitted a plan that checked all the boxes on Appendix D and were just handed a sketch plan from another company and said, emulate this. And so the only thing that we could figure out is that they had done theirs in AutoCAD, which is a drafting software, and ours was not. And so, you know, we didn't get any responses from the planning department. We were confused as to why it could be considered deficient in any way. And so we decided to have a GIS mapper drafted up in ArcGIS to make it look like Calpines.
And on March 8th of 2022, did Kimberly Hoffman, on behalf of MBS, submit a sketch plan under a cover letter to the planning department demanding that the planning department conduct a pre-application meeting for the project?
Yes.
And is that at Exhibit R?
Yes.
Are you aware that on the evening of March 8, 2022, the Levy Court introduced Ordinance LC 2209, an ordinance which would impose a temporary moratorium on new solar projects which had not completed a pre-application meeting on or before March 8th?
I did not know that at that time.
Is that ordinance at Exhibit S of
Yeah.
the notebook?
Yes.
But you didn't know it at the time. So then, on March 9, did you receive a review letter from the planning department?
We did. We got a review letter from the planning department that was on our first redraft done by our mapper. So again, after we had submitted the one on 3.4 that met all Appendix D requirements, we went back to the drawing board and submitted another attempt.
And is that shown at Exhibit T in the notebook?
Yes.
Okay. And are you aware that on March 11, Sam Judd sent a revised sketch plan to the planning department responding to all of the comments in Exhibit T?
Yes.
And is that shown at Exhibit U?
Yes.
Were you involved in reviewing this submission?
Yes, I was.
When did you find out about the moratorium ordinance?
I found out about the moratorium ordinance on March 14th.
And how do you know that?
So the document had been sent by Laird Stabler to Sam Judd, and then he forwarded it to me. And this was the retroactive moratorium that had been introduced on the 8th, and I was aware of it on the 14th.
And did the planning office request on that same afternoon that MBS revise its sketch plan to include dimensions of planted buffers on the layout?
Yes, that was one of their comments, but there was no mention of the moratorium.
And is that request from the planning department at Exhibit V in the notebook?
Yes.
And did MBS submit a further revised sketch plan the next day?
Yes, we did.
And what was the difference in that submission?
The only difference is that the setbacks and vegetative screening buffer distances, we put on the site plan instead of in the table on the side, which is not necessarily a requirement of Appendix D, but just a formatting request, which we did.
Is that shown at Exhibit W?
Yes.
Okay. And so there's nothing in Appendix D that requires the dimensions of the buffers to be on the layout as opposed to on a table on the layout or next to the layout, is that right?
No requirement to have to.
Okay, so this is just a formatting objection, is that right?
Yes. Mm-hmm.
Did the planning department ultimately accept MBS's sketch plan on March 16th?
Yes.
And is that shown at Exhibit X
Yes.
at page 2? Is
Yep.
that right? Mm-hmm. And then early in the morning on Thursday, March 17, did MBS participate in a pre-application meeting with the planning staff to review the project?
Yes, it was myself, Sam Judd, and Jamie Fensky were in that meeting.
And what can you tell us about that meeting?
You know, we went through just the basis of the sketch plan and the proposed use and the parcels, kind of what you would normally do when you're introducing a solar project or a project to the planning department. They provided some feedback. We had some questions on, you know, what was the rear or side of an agricultural parcel with regards to setbacks and various things. And Jamie was very helpful in answering all those questions for us to make sure that we had everything complete. Again, no discussion of the moratorium, no discussion, you know, of anything beyond that. She did mention that there was a moratorium that I had found out about on March 14th during the March 17th pre-application, and she did mention the ordinance LC 2205 that we were aware of as well. But, you know, the pre-application meeting was fairly brief and very helpful in guiding us on what we needed to do before the preliminary plan.
So after the pre-application meeting on March 17th, was there some discussion about submitting for plus review to the Office of State Planning Coordination?
Yep, so after the meeting, Jamie did reach out to MBS and just kind of asked us if we had registered or applied to the OSPC for a plus review.
And is that found at Exhibit X on page 1 of the notebook?
It is.
And so did MBS file a plus application on March 17th?
We did. We filed it that same afternoon.
And is that found at Exhibit Z in the notebook?
Yes.
And did the State Planning Coordination Office acknowledge receipt of the plus application and put the MBS project on the agenda for the April plus meeting?
Yes, on March 18th, so a day after we submitted, they did accept the application and put us on that meeting.
And that's shown at Exhibit Z, page 3 in the notebook?
Yes.
Okay. And at some point that morning, did MBS get some indication from the Office of State Planning Coordination that the Office of State Planning Coordination would grant MBS a plus waiver?
Yes. So Josh Thomas of the OSPC did advise MBS that we would be able to get a waiver, which is routinely done for solar projects because they're a very low impact land use.
And is that communication shown at Exhibit Z, page 4?
Yes.
And did you find out that someone at MBS had spoken with the Office of State Planning Coordination later that day, and that they were in fact going to provide a plus waiver?
Yes, we were told that if we submitted a request that we would be granted a plus waiver.
Okay, and that's shown at Exhibit Y, is that right?
Yes.
Okay, I'm not going to ask you to read that. I think the board can read that for themselves, but it appears to indicate that, that in fact, the Office of State Planning Coordination was going to grant a plus waiver. Is that fair to say?
Yes.
And then later that day, did someone from MBS submit a formal request for a plus waiver?
Yes.
And I think you said earlier that was at Exhibit Z, is that right?
Yes.
Okay, and so what happened next?
So on the morning, so that was a Friday. So on the morning of March 21st, 2022,
Let me ask the question this way, because I think it'll help cut to the chase a little bit. Did someone on behalf of the county indicate that, that we should apply to Plus? Did they ask if we had applied to Plus?
yeah, Jamie had asked us.
Okay, and did somebody on behalf of MBS indicate that the Office of State Planning Coordination said they would be providing a waiver?
Yes.
And shortly after that, did the Office of State Planning Coordination actually reverse course and indicate that due to some local sensitivities, they would not be providing a plus waiver?
Yes, it was after we had mentioned it to the planning department that we actually were going to be getting a waiver request put in and accepted, that shortly after the Office of State Planning and Coordination contacted us to say actually they were going to not be allowing that waiver.
And is that communication found at Exhibit BB in the notebook?
Yes.
And do you know if any other solar facility in Kent County has ever been required to go through Plus?
Not that I'm aware of.
And how do you know that?
I did my research on the Plus dashboard, and there were no solar facilities that had been applied for on that dashboard. In addition, I checked several of the solar facilities that I know have been either developed or are in planning, and none of them showed up on the dashboard as well.
Okay. Did MBS shortly thereafter submit a preliminary application to the planning office?
Yes,
And was that on March 21st?
it was.
And did Tess McMorris of ERM submit that?
She submitted on behalf of MBS, yes.
And is that found at Exhibit CC?
Yes,
And are you aware that on the morning of March 22nd, the next morning at 9:41 a.m., Jamie Fenske sent an email to Sam Judd, Tess, and yourself attaching a comment letter? Do you recall seeing that comment letter?
yep, I did.
And did Jamie's communication indicate that you should revise the plans to include all detailed information?
Yes, she gave us a list, and so we met all of those requirements in our next submission.
And that communication from Jamie is found at Exhibit DD, is that right?
Yes,
And so later that afternoon, did you submit a revised preliminary application to Jamie Fenske?
I did. So this would have been at 4:57 Eastern on March 22nd, 2022. I submitted the preliminary application to Jamie Fenske via email while a hard copy was being dropped off to the office.
And is that submission found at Exhibit EE in the notebook?
Yes.
Okay. And are you aware that someone named Marisol from Kimberly Hoffman's office had been sent to deliver a physical copy of the submission that you made electronically?
Yes.
And can you explain to the board what happened when Marisol went to the planning department?
Yes. So Marisol is an assistant for Kim Hoffman, who is our counsel. And she was tasked with taking all the paper copies and the application and the check to the county. So she was taking the paper copies when I submitted it electronically as well via a OneDrive link. And she ended up getting to the county office and was turned away.
I'm sorry. I was just going to say, do you recall why she was turned away?
Basically, I don't recall the specifics of it, but Jamie Fenske gave me a call and she said there was some confusion about what was or wasn't included in the submission. It was confirmed that we did have what she thought we were missing in the submission, and so she requested that I call Marisol right away and have her turn around so that she can keep the office open and accept the application.
And so did Marisol return to the county planning office?
She did.
And did she, in fact, turn in the application, the physical copy of the application?
She did.
And Jamie accepted it that evening?
She did.
And that was at approximately 5:30 p.m. on March 22nd, is that right?
Mm-hmm.
Is it your contention, let me go forward to, in our PowerPoint, to the preliminary application. Is it your contention that what was submitted on the afternoon of March 22nd was complete and should have been accepted,
Yes,
because it satisfies all of the requirements of Appendix D.
correct.
Okay. Let me ask you what happened later that evening. Are you aware that on the evening of March 22nd, the Levy Court adopted Ordinance LC 2205, the solar ban ordinance,
Yes,
and that ordinance effectively banned utility-scale solar projects on all AC zone properties located outside of the county's growth zone?
yes,
And is that ordinance found at Exhibit FF in the notebook?
yes.
So if we are correct here, and the application that was submitted on March 22nd by 5:30 PM was complete, then by its own terms, Ordinance LC 2205 would not apply to this application. Is that correct?
Correct.
Okay. So the next day, March 23rd, did MBS receive some indication that the preliminary application was not satisfactory for some reason?
We did receive a letter from Sarah Kiefer. It said that it didn't meet the standards for preliminary plan submission for reasons set forth in the letter that was dated 3/23.
And is that Exhibit GG in the notebook?
Yes,
Okay. And did Sarah's letter of March 23rd add any new or additional comments that Jamie had not included previously?
multiple. There were comments that were submitted by Jamie on 3/22, and then on 3/23, several additional comments were listed.
Okay, Madam Chair, at this time, I'm going to show the witness what you should have identified as review of Kent County Planning Department comments in rejection letter dated March 23rd, 2022. And I'm just going to ask Ashley to briefly run through this. It's a response to each of the comments in Ms. Kiefer's March 23rd letter. So Ashley, if you could walk through this as efficiently as you can.
I will do my best.
Mr. Party, this is up here. Just so you know, you're at about an hour mark.
Okay, thank you very much.
Okay, so county comment number 1, the survey that was delivered to the planning department on March 23rd conflicts with the preliminary plan. The survey data must be used for the preliminary plans. Survey monuments must be included in the data column and identified on the plan. Meets and bounds need to be included and legible. So the MBS response is that the survey was performed by Barry Gleisner with SAM, who is a professional land surveyor registered in the state of Delaware. It was part of the preliminary plan submission. If you look at all the contours on the preliminary plan, those are all the surveyed contours there by Barry. The property boundaries and topographic information is on the site layout, and here in this visual, I have helped you see where it's included in the data column with regards to the permanent monuments that are, and then also where the monuments are found on the plan and the meets and bounds. These are just snapshots of what was given to the planning department, yet it was said to be missing, and it is there.
And the next comment?
Comment 2, site data items must include survey data, wetlands delineation information, woodland preservations, accurate area within stormwater, number of inverters, number of batteries, number of concrete inverter pads, and number of concrete battery pads. So per Appendix D, the wetlands survey, stormwater, woodlands, and all the woodlands information is required. And if you see this snapshot of the site data table, which is actually on sheet 2 of the preliminary plan, circled in green is all of the information that they asked for. The other information that was mentioned in this comment, even though it's not required by Appendix D, was also included here, which is number of panels, inverters, and batteries. And we also included on the site plan where all of those would be, and even some details of what those inverter skids and battery skids look like for clarity.
Next comment?
Comment 3, delineated wetlands need to be identified on the plan. While the plan note indicates wetland delineation was completed, there is no evidence of such delineation on the plan. Please also include wetland setbacks. So, as mentioned in the comment, this bottom left corner says the wetlands delineation undertaken by ERM occurred from March 9th to 14th, so it gives the information of when it was delineated. They said that there was no delineation on the plan, but if you look at the green circles, all of that, that dotted area, which is shown in the legend as existing wetland, is on the plan, and there are 100-foot wetland setbacks included. It was said it was missing, it was clearly there. Comment 4. Reference topography contours to USGS survey data. Actual field topography needs to be used in the plan. So if you go to the note in the bottom left, it clearly says that the topographic and boundary survey was performed by SAM, which again, Barry Gleisner is a professional land surveyor in the state of Delaware, the week of March 6th. And then if you go to the plan, the topographic information is everywhere on the plan. There's dotted lines. You can see I've circled all the 1-foot contours. It was on the plans, not missed.
Next comment.
Comment 5, all easements, including DelDOT conservation easement, must be included on the plan. So these particular parcels have blanket easements. Blanket easements like conservation easements over them. They can't be physically located on a plan like a utility or a water well or things like that. So to make sure the county was fully aware of them, we put them in 2 locations in the application. We put them in the project narrative, which is circled here on the left, and we also added it to the general notes as well of the easements that were included. So again, you can't see an easement on it, but they're in the notes and referenced in the narrative, and they were provided as Appendix A as part of the application. There should have been no wondering of what easements were on the property.
Comment 6.
The plan formatted must include a cover page, overall page with 3 parcels, an individual page for each parcel, to include data column for that parcel, a landscape cover page, an overall landscape plan, and an individual landscape plan for each parcel. So these are all formatting requests. However, we actually did have cover sheets. We had overall plans and we have individual plans. If you look at the next 1, 2, 3, 4 sheets, those are some snapshots of what they said were missing, which are the first pages on the documents that were submitted. Comment 7, include overall soils and wetlands inset maps on cover page. Include all pages on the sheet index. So if you look at our response here, specifically to Appendix B, it doesn't say that the wetlands and soils and wetlands inset maps need to be on the cover page. That is a formatting request that we can do, but it was on every single other page of the site layout. And here's an example in the top right corner. Shouldn't have been difficult to find. It's right there.
Comment 8.
Comment 8, the proposed project is in the jurisdiction of Kent County, not the city of Dover. We are aware of this. If you look on the front cover page, it says governing agencies in bright bold letters. Kent County Levy Court. If you go down to required permits, it says as per Kent County Levy Court requirements. It's right there on there. Should have been no question.
You're not showing a project that's in the city of Dover.
No, we do have one parcel that's in the city of Dover. That wasn't part of the submission.
Okay. Comment 9.
All professionals associated with the project must be a Delaware registered professional. The below listed professionals assisted in the design, development, and submittal of the application and preliminary plan submission. Survey, we talked about Barry Gleisner. He's a professional land surveyor in the state of Delaware. Landscape architect from Becker Morgan, Chad Carter. He is registered in the state of Delaware. Engineer, Steve Sills from Atwell, registered in the state of Delaware. Keep in mind that a certification by the licensed professional is not required until the final plan stage per Appendix D. So if you look at the snapshot I gave you, you can see that the X for an engineer or land surveyor certification isn't until the final plan. They did prepare the documents. However, there was no certification because you don't stamp the documents as an engineer until they get to final plan stage.
Okay. Comment 10.
Comment 10, data column information should include accurate survey data, wetlands delineation, and woodland preservation. Here are examples of the tables that were included for each parcel. Circled in green are those quantities that they had asked for on the plan that was submitted.
Comment 11.
11, wood lines need to be included on all parcels and in accurate locations. If you look at this snapshot of the preliminary plan, we're using the most standard symbol for trees, which is a bubble line, which engineers and planners use often. And if you go onto the plan, you can see where that bubbled line is located, mostly around the treed areas, obviously around Morgan Branch and Little Creek. It's on the plans.
Okay. The next page has several different comments, and it looks like comments 12, 13, 14, 17, and 19 are similar in that they are formatting requests that are not required by Appendix D. Is that correct?
Correct. They are not a basis for refusing a plan. They're all formatting issues that could easily be adjusted to help the planning department prior to it going to RPC. Again, not requirements of Appendix D.
Okay. Can you give us one of the examples?
Sure, this one says remove duplicate parcel numbers and property owner information and remove horizontal and vertical lines from the plan. Often engineering plans have a grid on them. It helps you easily identify on large parcels where things are. They wanted us to remove it. That's fine. Has nothing to do with Appendix D and not a basis for rejecting the plan.
What about comment 18?
Comment 18 is not necessarily a deficiency that they're trying to list. It's just a question. It said, is grading taking place on the subject parcels? If the existing contours will be maintained and no grading is taking place, then grading plans are not necessary. We didn't have any grading, so we actually did more work in providing a plan with existing contours. They had more information than they needed.
What about comment 15 on the next page?
Comment 15, identify where the actual water courses are per the survey data. Well, per the notes, again, we had that delineated by ERM in the field, every single water course on all of these large parcels. And they're shown right here. Existing non-jurisdictional stream, existing non-jurisdictional stream, existing water course. It's all listed on the plan.
Comment 16?
The rear setback must be identified on the rear property lines and not as side setbacks. Well, if you look at this example below, as we talked about, with large agricultural parcels that don't necessarily have houses on them, it can be difficult to determine which is the front, side, or rear setback. We did our best to identify that in this case, this was a side setback. I still say that that is a side setback, but it should be irrelevant because if you look in the table to the right, the side and rear setbacks are the same, 75 feet. Again, not a basis for rejecting a plan.
And lastly, comment 20.
20, show all property lines. Remove red line as property line. Correct gaps in property line. Here's an example of the site plan of the property line. It is red. We did that to clearly identify the edges of the property line. If they want us to change it to black, we can do that. Again, not a requirement of Appendix D and definitely not a basis for rejection of the plan.
Okay. Thank you for taking the time to walk through that. So am I correct that on March 25th, Tess McMorris, on behalf of MBS, submitted a formal response to Ms. Kiefer by letter, and that's found at Exhibit HH in the notebook?
Yes.
And that basically laid out everything you just explained, is that right?
Yes.
Okay. And so did Sarah respond subsequent to that?
She did.
And is that found at Exhibit II in the notebook?
Yes.
And did Sarah say, I don't believe there's a path to proceeding, and the survey itself wasn't provided until last Wednesday?
That's what she said.
Is that true?
No.
The survey was provided.
Yes.
And can you explain how it was provided?
It was provided electronically as part of the submission via OneDrive at 4:57 p.m. on March 22nd.
Okay. And then Sarah's her email says the application was not complete and we could not accept it. Is that true?
No, it was complete.
You just explained why it was complete, that it met all of the Appendix D requirements. Is that right?
Correct.
And the last thing Sarah says is, as of last Tuesday evening, the use is no longer permitted in the AC zoning district. That's not true either, is it?
That's not true. It's only prohibited outside the growth zone in the AC district.
Okay. And so did someone from MBS subsequently reach out to Sarah on April 19th to ask for further consideration?
Yes.
And is that at Exhibit JJ?
Yes.
And ultimately, Sarah responded, we are not able to accept the application. Is that right?
That is correct.
And I'm not going to ask you to walk through what happened in great detail after April 19 of 2022, but is it your understanding that ultimately MBS filed an appeal from Sarah's determination? Is that right?
Yes.
And subsequent to that, the levy court introduced a number of different ordinances, ultimately adopting an ordinance designated as LC 2217, which effectively precludes utility-scale solar projects in all districts other than BG inside the growth zone.
Yes, that's correct.
Okay. Just a couple questions here and we'll wrap up. Did you get the sense that for some reason the county was slow walking this application?
I definitely got that sense. I mean, for the sketch plan submission and even for some of the preliminary plan submissions, they were quick in providing responses in a timely manner at first and being very helpful. But once we submitted that complete sketch plan on 3/4 of 2022, they gave us a really vague and unclear response, which was very uncommon for the planning department. Typically, their responses come back with bullets of all sorts of things like you saw in that March 22 letter. But they gave us no response on March 24. They just handed us a plan and said, make it look like this, even though we had clearly identified where we had everything from Appendix D. So, again, we didn't know that they were planning on a retroactive moratorium to be introduced on March 8th. Now it makes sense. They were slow walking it until that was introduced because it was on introduction of when it would be enacted. They knew we couldn't have our pre-application meeting prior to it being introduced, so they kept some critical information from us, and they intentionally slow-walked the process. With the preliminary plan submission, they definitely threw us some curveballs with the plus submission, and as you can see from some of the comments they had, they were very ticky-tack and definitely not a basis. And the fact was, too, is that a lot of the comments were of items they said were missing that were clearly in the plans if you just opened the plans. It just looked like they were trying to haphazardly cover themselves by listing as many things as they possibly could in a list to show that it wasn't complete, which I wish they would have taken that time to actually review it instead, because then they would have seen that the information was there.
Did you feel that MBS was somehow the victim of some external squabble that had nothing to do with the merits of the application?
Absolutely.
And why do you say that?
I feel like we could have put together the most phenomenal application that the planning department has ever seen, and they were still going to find some reason to reject it. And, the timing was unfortunate in that we got grouped together with the Cedar Creek project, which unnecessarily pitted the agricultural community against the solar community. And in addition, we were pulled into this family battle as well. And Paul Cartanza was going to do anything in his power to kill the project to spite his brother Chris, and it had nothing to do with the actual merits of the application. So I felt like we were going to be doomed no matter what we submitted for this project.
I'm going to place an objection on the record because it's all road speculation and it doesn't constitute testimony.
That's fine. I don't have any further questions for Ashley. If Max wants to ask her a question. Oh, sorry.
Bear with me, Ms. Smith, while I move the podium around. And I don't mean to take my back to you, we just don't have a good setup here. So could I ask you to take down the presentation that's up there right now? Thank you very much. Ms. Smith, it's nice to meet you. We met for the first time today. Is this your first project that you've done in Delaware?
No, it's not.
Okay, is this your first project you've ever done in Kent County?
Yes, I've done one in Newcastle, but not.
Okay. And help me, you gave a lot of testimony there. Back in March of last year, when you submitted the sketch plans and the preliminary plans, who did you work for at that time?
Dakota Power Partners.
Okay, and where was Dakota Power Partners' offices located?
Most of our employees work remotely, but we
Okay.
had our main office was in Denver, Colorado.
And did you have any, and is that where you lived at that time?
Yes.
And your main office was there. Thank you. I just want to know, did Dakota have an office in Delaware at that time?
We did not, no.
Okay. And I went and read the notes on the plan. That's what we do as land use attorneys. Were you the primary SHORTA coordinator of the drafting of the plans? Was that you?
I helped coordinate, but I was not responsible for drafting the plans.
Okay. Who actually drafted the the sketch plan and the preliminary plan, if you know?
So those would be representatives from Atwell,
Oh, good.
Sam.
That's what I thought.
Yeah.
Atwell. So who is Atwell?
They're a national engineering consulting firm. Actually, Sam is as well. We used all national firms.
Understood. And does Atwell have an office in Delaware?
They do not have an office that I'm aware of in Delaware.
So I was reading some of the things. So on the plan, it talks about Mr. Hicks. What was Mr. Hicks's role?
Who's Mr. Hicks?
Okay. On the plan, it talks about Mr.
Is it their drafter? Is he the drafter?
He's with Atwell.
Oh, okay, so he's the drafter.
Okay.
Yep.
Now, what specific role did Stephen Sills play?
He was the engineer of record.
Okay. That wasn't my question. What did he do specifically?
He reviewed the drawings in detail to make sure that they were in compliance with all regulations and requirements of the code.
If you know, how many hours did Mr. Sills bill on this particular project?
I would imagine he probably billed 7 or 8 hours, probably would be my guess.
All right, and he's not here to testify today, is that correct?
No, he's not.
Right.
Mm-mm.
And I think maybe not, because you had some issues with the counties using the CAD system. I think, can we agree that the March 4th submission was based largely upon Google Earth photos?
It was.
And so there was no actual sketch that was made. You used the Google Earth photos to overlay and depict.
Nope, it was a mixture of Google Earth, a program called PV Design, as well as PowerPoint to get all of the information into one document.
So who was the primary person who put that together?
I assisted with that. And then we also had our member of the GIS team as well.
So hold on. Who was the person on the GIS team that assisted?
Her name was Megan Sky.
And was that you who also, I'm just trying to get who participated in that submission, in drafting that submission.
I did. I did a lot of it. We had a group of people that were working together on that.
Understood. Now, I believe you're a professional engineer, is that correct?
I am.
And are you a Delaware professional registered engineer?
No, but the sketch plan is not required.
Understand.
To be
I was just
prepared.
asking a
the
question.
preliminary plan.
Just to be clear, you don't have a Delaware license number, is that right?
Mm-mm.
And you're not a Delaware registered professional architect, is that correct?
No, but our
All right.
landscape architect Chad Carter was.
I understand.
Mm-hmm.
And you are not a registered professional landscape architect, is that correct?
Nope, but Chad Carter was, who
And
did
you're-
our plans.
And you're not a registered land surveyor, is that correct?
No, but Barry Gleisner was, who did our survey.
So prior to coming in here today, and I heard your testimony about the Office of State Planning, were you aware that the David Edgell of the Office of State Planning submitted an affidavit?
I'm aware of
Okay,
that.
and you're also aware that Mr. Josh Thomas of the Office of State Planning submitted an affidavit?
I was aware of the first one. I wasn't aware of Josh.
And at the end of the day, do you have any reason to doubt the veracity of the statements, of the firsthand statements of Mr. Edgell or Mr. Thomas?
I think that there's definitely some confusion around the project. I'm a little surprised, and do you want to give any context to the letter that you're referencing for the?
If you read the affidavits, tell me if you have any reason to doubt the veracity of the statements within the affidavits.
I would need to reread the affidavits one more time just to make sure I can answer that to my best knowledge.
It's okay. That's all right. You can be evasive. All right. So is it your testimony today, as I understood it, that the sketch plan submitted on March 4th was acceptable and complete?
Yes.
And is it your testimony here today that the preliminary plan submission submitted on March 22nd was acceptable and complete?
Yes.
All right. So I'd like to walk you through a couple of your slides. So can we pull up, I think it's number 1 for me? No. Of ours, yes. Thank you. Thank you. So I'm not trying to be cute. I believe this is your slide.
It is.
Okay.
Yes.
So I'd like to ask you a few questions about that. So isn't it true that the information that you have listed here was not actually on the preliminary plan submission, but it was actually in the survey?
So it was in the preliminary plan submission that was submitted electronically via OneDrive at 4:57 p.m. on March 22nd.
Let me put a sharper point on my question. Will you agree with me that there was a preliminary plan submission and there was a survey that was part of that package?
The survey was in the preliminary plan. However,
Was
a
it-
supplementary survey plan was provided to help provide additional information for the county.
Now,
planning
let's
department.
make sure that we're talking about exactly the same thing, because I don't want to fight with you about things that I think are easy answers. My question is, were the monuments placed upon the actual preliminary plan, or were they only included as part of the survey?
I consider the survey plan as part of the preliminary plan submission. That includes the application, all of the waivers, and the check that goes with it.
So
That
you're-
is the preliminary plan submission.
So there's a document entitled preliminary plan that you submitted. Is that correct?
There is.
Okay, and on that document, are there survey monuments as set forth on your slide here?
There are, the bottom right-hand parcel number 1, there where you see that table, that those are shown. The number of permanent monuments found in place, 6 corners found and 14 corners to be set, is in the preliminary plan.
Well, we're going to have to hear some testimony about that later, so I'll just let it be. Let me go to this. Do you recall when the wetlands delineation report was dated for your project?
It says it right on there.
And what date was that?
It says report dated March 22nd, 2022.
And that's the exact same date as the preliminary plan submission,
It is.
Is that correct?
Yes, we did it that morning.
Okay. So isn't it true that you could not have used that report to prepare the preliminary plan submission because the report was issued on the same date?
Not true. So the data behind the report was used in the plan. The data was submitted and added to these documents. There's a written report that goes along with it that has to go to the Army Corps of Engineers. That's not the data that goes in the preliminary plan. Very different.
Is it your testimony here today that the wetlands are accurate and complete as depicted on the preliminary plan
Yes.
itself? Okay. Let's go to the next one. So I believe you said that there were only general easements on this plan.
No, there's specific easements. You'll see utility easements, you'll see pump houses, which is what the PH stands for. You'll see all sorts of lines that were caught during the survey when they went in that field and they did their one call. We have those tickets, so those can be available as well. And it's just these blanket easements that are very hard to depict on a drawing.
Is it your testimony here today that all easements are placed on the preliminary plan?
All easements per our PLS, Barry Gleisner with Sam,
Okay.
those are the easements. That's all I have to go by, is he pulled all of the easements and looked through title work to put them on there, so.
So regarding this slide, is it your testimony here today that there are no errors in the preliminary plan concerning the boundary lines for the property of Dover?
There may be some formatting errors, there may be some drafting errors, but I don't think there's anything that would be per Appendix D. If there's a drafting error where something's spelled incorrectly, that can happen.
I think my question is fairly straightforward.
It's not.
Is it your testimony here today that there are no errors regarding the preliminary plan concerning the boundary lines for lands or property in the city of Dover, as you have circled there?
I have not checked that. I know that we have the jurisdiction correct, and I know that we have met all Appendix D requirements.
Is it your testimony here today that having appropriate and accurate boundary lines for the project is merely a formatting issue?
No, the boundary lines are accurate per our survey. If there are some drafting errors, like spelling errors, or sometimes when you're drafting text, you attach it to something and then it can move when you print it. Anybody who's done drafting before knows that. So some things could have been shifted during the PDF process.
So is it your testimony here that the preliminary plan submission of March 22nd was good enough?
Our preliminary plan submission on March 22nd met all Appendix D requirements.
Was it adequate to meet the requirements?
It met all of the Appendix D requirements.
And was it acceptable and complete as of March 22nd?
Yes.
Okay. No further questions. Can I have a time, Barrett, where are we on time for each of the parties?
Sorry, I got two different clocks running here. So Mr. Pardee has had about an hour and 15 minutes, and you are at about 20 minutes.
So just one quick follow-up question. Ashley, did anyone at the Office of State Planning Coordination ever mention to you the Dover Air Cargo Freight Access Study at any time prior to March 22nd, 2022?
No.
Okay, nothing further. At this point, Madam Chair, we're, I think, finished with this witness. If she may be excused, I'd like to call my next witness, Sam Judd.
Surely.
Thank you.
Mr. Edwards, do you want to swear the witness?
Could you please please state your name for the record?
Sam Judd.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you.
Mr. Judd, may I call you Sam?
Yes.
Okay, Sam, I'm going to try to make this quick. It's my understanding that in the spring of 2022, you were employed by Enel as a senior development manager. Is that correct?
That's correct.
And how long have you been employed by Enel Solar in that capacity?
About a year and a half.
And what do you do? What are your job responsibilities in that role?
So I work on the whole development cycle for utility scale solar and storage projects. Includes basically everything to get a project ready for construction, dealing with the interconnection with the utility, dealing with permitting, environmental, and all real estate matters.
Okay, and what was your involvement with this project, the MBS solar project?
So as has been stated, Enel acquired the project from Dakota Power Partners in May of 2021. And in the fall of that year, I was assigned as the development manager for the MBS project. And I basically led the development efforts for Enel Green Power in conjunction with Ms. Smith.
Okay, so what was your role relative to Ms. Smith?
Well, Ms. Smith was, Dakota was kept on as a development consultant, and Ms. Smith was the lead consultant. And so we basically co-developed the project.
Okay, I'm just going to ask you some quick questions about the chronology that we've presented tonight. Did you help me prepare this document in anticipation of this proceeding?
Yes.
And do you have firsthand knowledge of all the facts in the chronology relative to the preparation and submission of the sketch plan, the PLUS application, and the preliminary site plan application for the MBS project?
Yes.
And do you attest that all of the facts in the chronology relative to those submissions are true and correct to the best of your knowledge and belief?
I do.
You heard the testimony of Ashley Smith prior to your testimony?
I did.
And can you corroborate from your own firsthand knowledge that all of her testimony is true and correct to the best of your knowledge and belief?
I can.
Were you aware of the introduction of Ordinance LC 2205 by the end of February 2022?
Yes.
And you were likewise aware of the introduction of Ordinance LC 2209, the moratorium ordinance, by the middle of March 2022. Is that correct?
That's correct.
And is it possible that the moratorium ordinance would not be adopted?
That's possible.
Was the previous moratorium ordinance introduced by the levy court actually adopted?
It was not.
Even if the moratorium ordinance was adopted, did you believe that MBS's application, once accepted, would be grandfathered from Ordinance LC 2205 and the moratorium ordinance?
I did.
And were you told by Commissioner Buxton that the only way to save the project was to get the application in before Ordinance 2205 was adopted?
That was told to Laird, but the group was told that, yes.
Okay. I don't have anything further for this witness. Mr. Walton may have a couple questions.
Just give me one moment. You can put me on the clock. Mr. Judd, nice to meet you.
You too?
Is this your first project in Kent County?
Yes.
And where do you live?
North Carolina.
And where's your main office?
Massachusetts.
And I think these are easy ones, but I don't want to try to get in a fight with you. Would you agree with me that Kent County planning staff does not adopt ordinances?
Yes, I agree with that.
And the Kent County staff, the planning department, they don't adopt code amendments, do they?
Not to my knowledge.
And I assume you would agree with me that the legislative body adopts ordinances and code amendments. Is that correct?
To my knowledge, yes.
And just to be clear, you're not, are you a Delaware professional, a registered professional engineer?
No.
And are you a Delaware registered professional architect?
No.
Are you a Delaware registered professional landscape architect?
No.
And are you a Delaware registered land surveyor?
No.
That's all I have. Thank you.
We have nothing further at this point, Madam Chair. I believe that our presentation in chief is concluded. We would reserve the right to call witnesses on rebuttal.
Thank you.
Madam Chair, is it desire of the chair for us to present our our witnesses now, or would you desire a 5-minute break at this
I'm
time?
thinking perhaps we may need a 5-minute break, or some people may need a 5-minute break. So it's 8:20, and let's resume at 8:25.
Thank you.
Ashley, you are a fireball. I love it.
Sorry. I tried to hold it back for you, but I couldn't.
Oh, it's good.
Because we're going to start running out of time, I think I'm going to pare down some of what I'm going to ask.
It all depends on how long your answers go, too, because they can be really short and then you won't be too long.
I thought you did a great job, by the way.
I didn't do anything. You did everything.
Oh, I was like sweating. Okay.
Play these games, just show objections, just dragging out time. What's that?
Would it make sense to ask them? The only utility scale project we considered district does that.
At the time, that's one of the questions I'm going to ask.
Okay, you have that, yeah. All right.
That, at the time that you introduced,
Yeah.
were there any other projects that would have been caught up in it? I mean, that all goes to the timing of when they introduced it. Because
Other than Calpine, already had their pre-app, and was approved on
they were already in the system, so they wouldn't be caught up in the moratorium. So the key question is, at the time, so you have the March 1st, the agenda of the March 8th meeting is posted, and there's no moratorium ordinance on it. You submit your preliminary on March 3rd, boom, March 4th, they tried to amend the agenda, and they screwed it up.
Yeah.
But then they did add it on March 7th, and, so it's, the question is, were there any other projects
Yeah.
that we're trying to get in at that point in time?
What were you trying to do?
And the thing is too, is like, that the PQ is public.
Yes.
All of that information, they have all the information of who's applied for solar projects,
Yep.
for interconnection. So, the list is there, right?
Yeah, they should know.
After we told them.
Yeah.
I just want to use this time to try to.
Yeah, you do.
Did you research the fact that when they sold this ground, Cortez bought it, so it ended up
I gotta get to that later, okay? That's not what this hearing's about. That's for another hearing. That's for another
I want to
hearing.
make sure you're aware of it.
I'm aware of it.
Yeah, okay.
Aware of it.
Thank you very much.
All right. So help me out with my, when do I pull the slide up?
Yeah, so this, right there is when you're like, okay, so now I'd like to show you, so let me pull it. I knew that was going to be, you don't have to ask her about that, but I just thought that was really funny that they're like, oh, we sent it over, sure. And then they give precise times for everything. Okay. Let's say it, mention it if it's wrong. I think that's fine.
Oh my God, you know, this is why you can't get anything. Listen, in North Carolina, I can go to Raleigh and get me a lawyer. They'll earn 10 lawyers to the ground. They don't care because they make money in Raleigh. Well, in Delaware, it only goes so far because you're going to meet them again no matter what. So people don't understand how that because they'll only go so far with each other. Yeah, they don't want to burn bridges. I'm going to Charlotte on Sunday.
Okay, everybody needs to be ready.
I mean, twice. Very nice.
I do have to wait a moment because one of our members from the planning department, here he comes, okay.
Can we have a quick discussion just really fast? I have this podium set up and it's at an odd angle. We're going to be using this teleprompter device. So I'm going to have our witnesses stand over here. I don't mean to partially turn my back to the board, but it's the only way we can
Yeah, it's the only way you
done.
can do it, and I fully understand. The most important thing is that because we're recording, is that that we have a mic so that when they're standing there, we can hear them.
Yeah, so we're going to use a remote mic.
Okay, that's fine,
Okay.
we have one. Okay, thank you.
So the department calls Jamie Fensky.
Typically, what we do is when we all return, we do call the roll to be certain that we have a quorum. I'm sorry, but
I'm sorry, I wasn't aware of
no,
that
that's
procedure.
okay, but no, of course, let me just, when you're ready, would you mind just,
No problem, absolutely. Mr. Jenkins?
Here.
Mr. Jones?
Here.
Ms. Hudson?
here,
Mrs. Denny?
here.
Chairperson, we do still have 4 members present. We do have the quorum.
Thank you so much. Thank you.
And just as a procedural matter, is there any objection to all of Mr. Party's exhibits that he has provided being entered into the record? No objection?
Mr. Edwards, it was my understanding, we also did a narrative timeline and things that were also placed in the record. I'm not going to go through each exhibit as Mr. Pardee did, but it would be my assumption that all of those items that we submitted are also in the record.
Yeah, absolutely. We can do that now or at the end of your testimony, doesn't really matter.
So I'll just move them in because I'm not going to refer to that much.
All right, perfect. So with no objection, all the exhibits that have been provided by both parties are part of the record. Thank you.
No objection.
Maybe I'll try again. I'd like to call Jamie Fensky. How are you this evening, Jamie?
Good, how are you?
Please state your name for the record.
Jamie Fensky,
And what's your title?
planner at Kent County.
Can everybody hear Jamie? Hmm? Oh, Barrett, Erica's reminding me I got going a little fast. I think you need to swear her.
Between me trying to keep track of the different clocks up here, there's a lot going on. So, do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you.
I'm going to start this again. What is your job title?
Planner at Kent County.
And what does your job entail generally?
reviewing site plans, reviewing plot plans, permits, additional uses.
And how long have you been doing plan review?
I've been with Kent County Planning for 3 years.
And can you just generally describe your involvement with the plan review process for the Morgan Branch application?
Yes. So originally the sketch plan was sent to me. I had reviewed all the sketch plans and all of the preliminary plans that were submitted.
If you recall, when did you first receive the sketch plan from Morgan Branch?
I received it on March 4th.
And after you reviewed it, what did you do, if you remember?
I sent them an email referring them back to the Kent County Code.
And did they submit more than one sketch plan on March the 4th?
Yes.
And I think we already heard the testimony that there was a second version on March the 4th that was submitted. And I think they argue that that should be accepted. Can we state, is that the way you understood the testimony?
Yes.
I'd like to show you Morgan Branch's presentation, and maybe we could go with that. But before we start, do you agree that with the testimony that you've heard, that the March 4 sketch plan complied with the Appendix D requirements?
No, it does not.
All right, let's just go through their slides. So we'll go to page, Pete, tell me. We'll go to page 1 of the March 4 sketch plan. What do you see on this plan that is wrong or missing?
So this parcel here is in the city of Dover. It is not in the incorporated limits for the county's review for planning.
Is that a, I forget the word that was used, is that some kind of a technical error, or is that a material error?
Well, we had discussion with them that that's in the county, or I'm sorry, that's in the city of Dover, not in the county.
So let's go on to slide 2 or page 2. What do you see on this page, and what's wrong or missing?
So the property owner is not Christopher Cartanza, it's Christopher Cartanza trustee. The parcel number 4 is in the city of Dover, not in Kent County's jurisdiction. The surveyor is not Sam Inc., it is Sam LLC.
So let's go on to page 4 of that same submission. And what do you see on this page that is wrong or missing?
So on this, they just have different colors. The existing watercourses comment was not included on this original sketch plan. So there was just reference to colors with no legend, labeling if they're blue line stream, wetlands, tax ditch, no reference to what the colors are.
So just to be clear, those yellow boxes aren't on what you received.
Correct.
And why is not having those, all those items labeled, why is that a problem?
There's different setbacks for each of them. For example, the blue line stream would have a 100-foot setback from top of bank, where the wetlands would have a 25-foot setback.
So let's skip ahead. I'm just going to go to page 7. And for the board's edification, we didn't want you to be here all night to have to go through every slide, so we're not going through everything. We're just going through hitting the high points.
Thank you, but take as much time as you need.
Understand. So we're on page 7. What's going on here?
Again, this parcel here is in the city of Dover. It's not in the county, Kent County's jurisdiction. In the legend there, you'll see the wetlands, they're in white. It's very confusing down there on the plan. The property lines are not dimensioned.
So they list setbacks, I believe there. Any significance to that?
The setbacks are listed over there. The wetlands is wrong, it's 25 feet, but they're not included on the plan.
And what's the significance of that?
To show where the actual panels and inverters and batteries can go, because they would have to meet all the setbacks.
So let's move on to page 8. And again, were these yellow boxes on anything you received?
No.
There's a lot going on here. Can you tell us what you see, which may be wrong or incorrect?
Sure. So over in the legend, you will see that the parcel boundary is labeled as a black line. There is no black line on the plan visually. The stormwater control, you will see the 2 blobs on there, But over in the box in the right-hand corner, it indicates that the stormwater management area is 21 acres of the 66 acres. You can see they're not proportioned to scale. Also, the wooded area that's over here, the wooded area goes all along here. It doesn't identify what this yellow dotted line is. These are 5-foot topos.
Well, let's stop you there. With 5-foot topos versus 1-foot topos, what's the significance?
Well, there's a huge difference. The USGS gives the 5-foot topos. The 1-foot would come when they go out there and do the survey.
Was there anything regarding buffers that you noticed?
There is a green vegetative screening, but it doesn't indicate how large that is.
Does this include reference to proposed drainage facilities or parking facilities?
No.
Does it include the layout and dimension of all streets, alleys, and entrances?
No.
So let's go to the next one. And this is page 9 of their presentation. Tell us what's going on here.
Again, the property is not dimensioned. The green vegetative screening is not dimensioned with the right buffers. Wetlands is showing that it's 100 feet. The stormwater on there is showing just this little blob. Where over in the right-hand corner, it's saying 63 acres of 219. That's not to scale. The surveyor is still listing Sam Inc. when it's Sam LLC.
And was there an issue with respect to the wooded areas?
Yes, again, it's just labeling wooded area over here, but not indicating where the wooded area is.
Does this page include references to proposed drainage facilities and proposed parking facilities?
Does not.
Does this slide include reference to layout and dimension of all street, alleys, and entrances?
Does not.
And are those Appendix D requirements?
Yes.
Let's go to page 10. What's going on here?
Same thing, the property is not dimensioned. The black line to the left that says parcel boundary is not included on there. The stormwater on this one is saying 59 acres of 247, but per the legend, this is the only stormwater over here. The wetlands, again, is confusing. Down in the bottom corner, it just has a white circle around it. The buffer is not dimensioned. Setbacks are not dimensioned.
So does it include reference to proposed drainage facilities or proposed parking facilities?
Does not.
And does it include reference to layout and dimension of all streets, alleys, and entrances?
Does not.
And again, is that an Appendix D requirement?
Yes.
And with regard to the tiny little stormwater management facility over there that's depicted, is that 59 acres?
No.
Let's go to page 11.
This parcel is located in the city of Dover.
All right. So before we move on, and I'm probably going to have to go to my glasses to help you with this, you saw Mr. Pardee talk about a checklist
Yes.
that they submitted, and I put it up there on the screen, so I'm going to get my glasses out. So there are a number of items that are marked NA. That are marked NA. Are there items that are marked NA that are required items?
Yes.
So, for example, do they have an accurate location map?
An overall map, yes, but it included a parcel in the city of Dover.
What about the total woodland preservation?
No.
Is that listed as 0?
Yes.
So topo of 1 foot or less, they say they provided that. Is that accurate?
No.
They mark alleys as NA. Is that an inapplicable requirement?
They would need that.
And they mark the easement as NA. Is that an inapplicable requirement?
No, and is very important on this project.
Are there other significant natural or man-made features that are NA?
Yeah, they didn't include the tax ditches. Like I said, the wetlands are not mentioned.
We talked about the setbacks before. Did they meet the setback requirement?
No, they only showed it in the data column and did not show it on the plan.
So was this sketch plan incomplete on March 4th?
Correct.
And was it acceptable on March 4th?
It was not.
Okay. I think we've now established why the department deemed this submission incomplete and did not schedule the pre-applications. Do you recall how many versions of the sketch plan you had to review before you finally got a version that was acceptable?
6.
And if you recall, what date did an acceptable version come in?
March 16th, I received it.
Okay. On or before March 8th, did Morgan Branch submit an acceptable sketch plan submission?
No, they did not.
And usually when you have a sketch plan, do you usually see one based upon Google Earth?
No.
So, hold on, I want to make sure I got your testimony right. So sorry. I believe you said you received a final acceptable sketch plan on March 16th. Did I get that right?
Correct.
And so they were talking about delaying, you were having delays. What date did you schedule the pre-application meeting?
The next day, for March 17th.
And how long do you have to schedule a pre-application meeting?
5 days.
Why did you do it the next day?
Trying to work with the customer to get them in because they were working on the sketch plan for so long.
And were you aware of, or were they aware of the deadlines they were trying to?
Yes, we discussed them during the pre-application meeting.
So tell me your recollection of the pre-application meeting. Who was there and what did you discuss?
Ashley Smith, Sam Judd, and myself. It was a virtual call. We discussed, everything they had included on the sketch plan, what would be necessary for the preliminary plan. We discussed the moratorium ordinance and the solar ban ordinance.
So just to nail it down, you discussed the specific requirements of the moratorium ordinance at the meeting?
Yes, sir, with the dates.
And you described the specific provisions of the solar ban ordinance at the pre-application meeting?
Yes.
So after, anything else you'd like to add or that you remember about the pre-application meeting?
No.
All right. So this is a little bit of a memory test. So ultimately, do you recall after the March 17th meeting, what was your next communication?
Was on the 21st when I reached out to them, asking them if they had a preliminary plan that they would like to submit to us for us to review digitally prior to them dropping it off at the office.
Why'd you reach out proactively?
Because the deadline was the 22nd.
And what was the response that was received?
That they were still working on it.
And did they end up submitting that day or very soon thereafter?
They did. I believe it was that afternoon.
So am I right that a plan had to be deemed acceptable as of March 22nd under the solar ban ordinance?
Yes.
All right. So when you got their preliminary plan submission on March 21st and March 22nd, what did you do?
Quickly reviewed the plan, saw that it was still missing items, and sent them a comment letter on the morning of the 22nd.
And is this your comment letter?
Yes, it is.
Was that letter meant to be a complete review of everything that they would need to have an acceptable preliminary plan?
Not at all.
And how long did you actually have to review their submission before you wrote this detailed letter?
Very quickly.
And did they submit another set of plans? I'm sorry, I think your letter's dated.
The 22nd.
Yes, it is, March 22nd. So they submitted another set of plans. Did you have a chance to review the revised plans that same day?
Very quickly. We reviewed them very quickly in the office, and at first glance, we thought they were missing the survey and the wetlands delineation. After they left the office, we saw that the wetlands delineation was sent to the Army Corps that day. So I called them and had them bring back the plan for us to review it further.
What happened the next morning?
Sat down in the conference room, reviewed the plan. While I was reviewing the plan, the surveyor dropped off the survey. So the survey was dropped off about 9:30 on the 23rd.
And were you reviewing the actual plan submission at that time?
Yes, and the survey that was dropped off did not match the preliminary plan that I was reviewing.
What did you determine ultimately?
That the preliminary plan was not completed with the survey, the wetlands were not completed with the survey, and neither were the topos.
And was there a letter drafted outlining deficiencies within the plan application?
Yes, there was.
And who drafted that letter?
Myself
And then who signed it?
Sarah, the planning director.
All right. So if you know, what does the code require you to do when you receive an incomplete submission?
Return it back to the applicant.
And is that what you did here?
Yes.
All right. Similar, I'm sure you heard the testimony, and they went through presentation, and went through the department's review letter, and there were commentary issued on those. I'd like to walk you through that, and maybe you can tell us why you disagree with them. So let's go up here and we'll go to, so this is on, starting with page 1. What are we looking at?
So this is what was submitted by Sam, the surveyor, on the morning of the 23rd.
Okay, and did they submit this on a single page?
There were several pages to this, but it was not included as part of the preliminary plan.
And when you review the preliminary plan, what are you reviewing?
One document that includes all of this information. Should include all of this information.
So I think you heard the testimony earlier where they said everything was submitted to the department in some fashion. But when you conduct a plan review, do you usually flip through between all the supplementary information to try to piece it together?
No.
Why not?
All of that information should be included on the preliminary plan. The survey showed that the acreage was different, so the preliminary plan was incorrect on that alone.
Okay, I'm going to go to their next slide. And what do you see here?
To start, the number of inverters, batteries, pads, all of that is blank, but they show on the plan that there were inverters and batteries. The total property, the acreage does not match the acreage that was provided by Sam, the surveyor, on the 23rd. The wetlands is the same acreage that was included on the sketch plans that were submitted on March 4th.
Just before we go to the next slide, whose responsibility is it to know the requirements of the code and to make the submission?
The applicant.
All right, let's go to the next slide. What is this? Or what are the issues here?
So this is showing the wetlands, but again, this is not depicted with the survey. So it's hard to tell if the wetlands are actually showing on the property because this is not the surveyed property line.
Is there anything with respect to the boundary and topographic survey showing different distances and meets and bounds?
Sorry, say that one more time.
Was there any issue with respect to the differences between the survey and this plan?
Yes.
Okay. So when there's some items circled there, is the acreage that's listed there, is that something that was on the pre-application sketch plan?
Sorry, the acreage?
Are you on the right slide?
Hold on. Help me. Right slide.
Are you here?
Sorry, we got a little confused. You were trying to go too fast.
Take your time.
Is that the right side?
For topos.
Thank you. Sorry, I got a little confused myself. I apologize to the board. It's a lot of lines and things that I need to keep up with, so my apologies. Tell us about this slide, and I will say that there's some items, that red line was added to the slide that you have in front of you in their presentation for demonstration purposes. Can you tell us about those red lines?
So these red squiggly lines here, these are not a part of the subject property, but yet they are showing that topos were done on these other properties. So you'll see that there's topos on this property here, along down here, and all along here. Again, these are not part of the subject property. This was not done on the survey. It's hard to believe that they went out and did topos on several other people's property,
So what does that indicate to you, if anything?
that they did not go out there and survey the topos themselves.
Okay. So let me go here. It says here that Morgan Brown Solar chose to clearly indicate the presence of conservation easements within the notes on the title sheet of the boundary and topographic survey plan, and they all go on to say information about these easements was included in the project narrative along with copies of the actual easement documents. Is that sufficient?
The survey was submitted on the 23rd. This was not included on the preliminary plan.
Okay, and so the next is county comment. Let me just check. Yep. So in this slide, just for the board's edification, we added the portion that's sort of outlined in red here. Can you tell us what slide 8 represents and what your addition means?
Yes. So in this red box down at the bottom, it's showing, if their line was correct, that this subject parcel is in the city of Dover, and that is incorrect. This parcel is in Kent County's jurisdiction.
All right. So let's go to comment 10. I'm talking about comment 10